Hi, I'm Whitney Espich, the CEO of the MIT Alumni Association, and I hope you enjoy this digital production created for alumni and friends like you.
Hi, good evening. My name is Patrick Gertis, and I'm the chair of the Black Alumni of MIT, or BAMIT, Board of Directors. And I just want to welcome you all for this evening's very, very interesting session on the battle for affirmative action and pursuing educational equity. At BAMIT, we recognize the importance and the fact that equitable access to education is a cornerstone of the fight for civil rights and a more just, healthy, vibrant, and economically robust society. So we are very excited this evening to welcome Jin Hee Lee, the Director of Strategic Initiatives at the Legal Defense Fund. Ms. Lee is going to be discussing the affirmative action cases that are pending before the U.S. Supreme Court and the implications of the court's rulings on academic institutions and education in America. We're very excited to learn as much as possible about these cases and the role that the Legal Defense Fund is playing in challenging the lawsuit. And we hope that you will learn with us. And as a result of this experience, get more engaged and more involved with the things that are going to be changing as a result of the ruling once it comes from the Supreme Court. So this evening, we're going to hear first from Jin Hee Lee, and then we'll have a Q&A session, and we'll have Willard Standback, one of our BAMIT members, who will be sitting with and asking some questions of Ms. Lee. We'll go from here. I will turn it over to you, Jin. Thank you.
Thank you so much, Patrick. And I really want to thank the Black Alumni of MIT for having me this evening. This is such an important institution, and affirmative action is such an important issue. I am going to share my screen. I have a few slides as part of my presentation. There we go. So I really love the title, The Battle for Affirmative Action, because it implies that the battle is still ongoing, that it's not over. And if you read the news, it almost seems like it's predetermined what the decision is going to be. But we like to, at the Legal Defense Fund, make very clear that the battle is not over. We still have not received the decisions from the Supreme Court, and there's a wide range of rulings that the court may have. But I thought I would begin by talking about, what affirmative action is and what it isn't. And of course, we're talking about higher education. It's a very specific area of law. And the way that affirmative action has developed in higher education has really been dictated by Supreme Court opinions. So to kind of dispel misinformation, I just want to be very clear that when we talk about affirmative action, we are not talking about a quota system. We're not talking about automatic benefits based on race or racial preference. These are terms that people often use, which are inaccurate. And it certainly does not mean the admission of unqualified students. What affirmative action is, based under the Supreme Court jurisprudence, is an effort to achieve the educational benefits of the diversity. That is the compelling interest that the Supreme Court has said that allows colleges and universities to consider race as one of many factors. And the reason why affirmative action is needed is because the playing field is not equal. We need to equalize the playing field because of the incredible inequities in our K through 12 educational system, so that everyone does not have the same opportunities to have the same the opportunities to have the same types of credentials that makes one competitive, or the most competitive, for highly selective colleges and universities. And so affirmative action is equalizing the playing field for students who had barriers to educational opportunities. And as I said before, it is considering race as one among many factors in an individualized holistic process. So there's, as many of you know, as all of you know, we apply to college. Colleges and universities consider a myriad of factors. They consider, obviously grades and sometimes standardized test scores, but also your intended major, your socioeconomic status, whether your parents attended and finished a four-year higher educational degree. Also considering geographic area, the high school that you attended, the courses that you took, your extracurricular activities. And what affirmative action allows is for colleges and universities to consider race as among all these other factors when trying to think about the diversity of their student body. And this is an individualized and holistic process. So it's not as if, you know, all student applicants of a particular race get the same bump or same bonus or anything like that. Nothing is that automatic. It's looking at each individual and each individual applicant and seeing their whole person. And most importantly, this is about admitting students who are qualified. When we talk about competitive and highly selective colleges and universities, there's too many students, too many exceptional students who are able to succeed and thrive in that institution. And so so many schools like MIT have the luxury of, and well, not only luxury, the difficulty of having to choose among many exceptional students. So we're talking about admissions among qualified students. And as I said, the way that the affirmative action has been developed has been really dictated by Supreme Court decisions. The first one is Regents of University of California versus Bakke. This is a case dealing with University of California, Davis Medical School. And this is in 1978. And even though this was not a majority decision, the one justice whose vote had the plurality was Justice Powell, really set forth the parameters of what is allowed in affirmative action in higher education. This has been followed by a pair of cases out of the University of Michigan. Gratz, Fink, Bollinger dealt with the University of Michigan undergraduate school. Grutter v. Bollinger dealt with the University of Michigan Law School. Even though the affirmative action program in both Bakke and Gratz were overturned because it did not follow the dictates, the parameters set forth by Justice Powell, it did establish that affirmative action was permissible under certain circumstances. And in the Grutter opinion, that's a case in the University of Michigan Law School where the affirmative action program was actually upheld. And then it was upheld again in the two Fisher cases. It's actually the same plaintiff, Abigail Fisher, who sued the University of Texas at Austin, and it went to the United States Supreme Court twice. And in both instances, the United States Supreme Court yet again reaffirmed the legality of affirmative action in higher education. And in the second case, Fisher too upheld the University of Texas's affirmative action program. So the body of law pertaining to affirmative action has been stable and has been consistent for almost 50 years. And so this is why for the Supreme Court to make a departure from this case law would be quite dramatic. It would be along the lines of what happened around abortion rights, because this has been settled law for such a long time. Now, going back to the Fisher 1 and Fisher 2 cases, this is Abigail Fisher, who's the plaintiff, but the person who is really behind these lawsuits is a man named Edward Bloom. And he's someone who is vocally opposed to affirmative action, as well as the Voting Rights Act. He was largely responsible for the litigation in the Shelby County litigation that went to the Supreme Court that many have criticized because it has really kind of gutted the ability of using the Voting Rights Act to protect voting rights in many jurisdictions, especially in the South. So after the losses in Fisher 1 and Fisher 2, Mr. Bloom changed course and created an organization called Students for Fair Admission, SFFA. And this was an organization that purported to represent the interests of Asian Americans. So thus far, in all of the cases that I talked to you about before, there were white plaintiffs who had sued universities because of their affirmative action program. Edward Bloom decided to try a new strategy and have Asian American plaintiffs sue universities for their affirmative action program. But instead of having individual plaintiffs, he created this organization that purported to represent Asian Americans. Now, even though it's an organization that is supposed to represent Asian Americans, Edward Bloom is the founder and is the head of the organization, as well as Abigail Fisher and her father. They're the other members of the board of directors. Students for Fair Admission filed lawsuits against Harvard University, which is a private university, and then the University of North Carolina, Chapel Hill, which is the oldest public university and the flagship University of North Carolina. They've also filed lawsuits against the University of Texas at Austin and Yale University, but those cases are still pending in the district courts and the lower courts and has not risen to the level of the United States Supreme Court. But both the Harvard and UNC case are the two cases that are before the Supreme Court right now. And we expect a decision pretty much any day now, anytime between now and June when the term ends for the Supreme Court this term. So there's some significant differences between the Harvard and UNC case, which might lead to some differences in terms of the rulings in the two cases. There's obviously some similarities, but there are some important differences. One of the most important differences is that Harvard is a private university like MIT, UNC being a public university. Because Harvard is a private university, it doesn't invoke the Equal Protection Clause of the 14th Amendment. That only applies to state actors, public actors. That's why in the UNC case, the law that's at stake is the 14th Amendment. And as in the Harvard case, it's Title VI of the Civil Rights Act. Because Harvard, as almost all educational institutions receive federal grants, it's required to comply with Title VI of the Civil Rights Act, which is a non-discrimination or anti-discrimination statute. The other difference between SFFA and Harvard is that currently before the Supreme Court in the Harvard case, there is a claim of intentional discrimination. Now, both Harvard and the UNC cases involve an effort to overturn Supreme Court precedent, overturn the cases that I had talked to you about previously, and have the court ban affirmative action outright. So that's the commonality between the two cases. But in the Harvard case, there's this additional allegation that that's before the Supreme Court, and that's the court is going to decide on, which is that that Harvard intentionally discriminates against Asian Americans through its affirmative action program. That is not an issue that's before the Supreme Court in the UNC case. Another kind of interesting difference between the Harvard and UNC case is that the Harvard case went through the normal appeal process. So both Harvard and UNC had a full trial, had an exhaustive opinion from the district court in both cases, which affirmed the affirmative action programs in both of the universities. In the Harvard case, it was appealed to the First Circuit Court of Appeals, which is the intermediate court, and from there went to the United States Supreme Court. And that's the normal course of appeals in these types of cases. In the UNC case, instead of going through to the appeals court, so normally it would go from the district court to the U.S. Court of Appeals for the Fourth Circuit, and then perhaps go to the United States Supreme Court. It skipped that intermediate level, went straight from the district court to the United States Supreme Court. That is very unusual. It's very difficult and very there are very few cases that are accepted by the United States Supreme Court on appeal, regardless of what appeals court it comes from. But to have a case heard directly from the district court is unusual. Many think that it was an effort to hear both cases together, which may very well be the case, but that is very unusual. Another difference between the two cases is whether or not Justice Ketanji Brown Jackson would be able to participate in the ruling. In the Harvard case, she recused herself because she had been on the board of governors at Harvard. She's a Harvard alum, but she is going to participate in the ruling in the UNC case. And it was present during oral argument for that case, but was not present for the oral argument in the Harvard case. So those are some of the two. So these are some of the distinctions between the Harvard and UNC cases. Now, just a little bit about LDF's participation in these cases, because these are cases that were filed against universities. Those are the parties, is the plaintiff, SFFA, and then there's the defendant, which is the universities. And of course, missing from these parties are the students themselves. And so we felt it was really important to represent the students. So we at LDF represent 25 Harvard student and alumni organizations that represent a wide array of racial and ethnic backgrounds. And this includes every major Asian American student and alumni organization, which is obviously quite notable given the claim of intentional discrimination against Asian Americans. But this is a photograph of our clients, our student clients, at a rally that was around the time of the trial. We participated, we represented the students and alumni at the trial level and participated in trial. Some of our clients actually testified as witnesses at the trial. We also engaged in opening and closing arguments, and we also presented argument in the First Circuit Court of Appeals. We were unfortunately not allowed to participate in the argument before the Supreme Court, even though we requested that opportunity. In the North Carolina case, we do not represent students, but we felt compelled to submit an amicus brief, this time on behalf of LDF and the National NAACP, because of very shocking arguments made in the briefs that SFFA submitted, arguing that affirmative action was akin to the Plessy decision. And for those of you, knowing your history, Plessy was a widely discredited opinion by the Supreme Court that had allowed Jim Crow laws to continue and to say that racial segregation was constitutional in the United States Constitution. That decision was overturned by Brown v. Board. And so as the legal organization and the clients that litigated Brown v. Board, we felt it was really important to weigh in and explain to the court how shocking that position was and how wrong it was under the 14th Amendment. But that just gives you a sense of how the plaintiffs SFFA have been using the 14th Amendment, the US Constitution, the Brown decision for its own purposes to argue that affirmative action should be banned, as opposed to the need for affirmative action for greater racial equity, especially in the educational system. Also notable, there are many amicus briefs that were filed in support of the universities and their affirmative action programs. But one thing that was notable is that 82 corporations submitted amicus briefs, and they signed on to 2 different amicus briefs in support of affirmative action, recognizing that diversity in higher education has tremendous ramifications for the diversity of the workforce, which is really important in terms of their own business productions and success. So this actually exceeded the number of corporations that submitted amicus briefs in all the other affirmative action cases. So really demonstrating how important affirmative action is, not only to students and to universities, but in civil rights organizations, but also to the business community. So here is what happens. Here's what's at stake if affirmative action is banned. And this is information from the Harvard case, which I'm mostly familiar with because we had been involved at the trial level. So, based on analyses of, and this was not disputed by the plaintiffs, if affirmative action is banned, that would affect a tremendous number of Black and Latinx students at Harvard. There would be approximately 1,000 fewer Black and Latinx students in the Harvard student body. And it's not, and what's interesting is that even though there's an allegation that there was discrimination against Asian Americans, those students would not necessarily be substituted by Asian American students, but in fact, white students. And so the percentage of Black students would decrease from 16% to 6%, and 14% Latinx students to 9%. And again, going back to a point that I made before, and I want to emphasize this because there's so much misinformation about this. It's not to say that those 1,000 students who would not have been admitted are not qualified or would not succeed at Harvard. The problem is, and I'm sure this is very common to MIT as well, there are 35,000 students who apply to Harvard for 2,000 spots for admission and in 16 with matriculation, 1,600 spots in the first year class. Of that, 2,700 applicants have perfect verbal SAT scores, 3,400 have perfect math SAT scores, over 8,000 have perfect GPAs. And this is considering that SAT scores and GPAs are not the only considerations that Harvard has in terms of its admissions process. So we're talking about a highly competitive pool of students, and among those highly competitive, students, who gets admitted and who doesn't, and the use of affirmative action to ensure that among that highly competitive pool, that there is a racially diverse incoming class. A major part of the intentional discrimination claim was a statistical analysis that was conducted by SFFA. And I am not a statistics expert, but there were a lot of differences between the statistical analysis conducted by Harvard's expert and SFFA's expert, which obviously led to different results and really shows how the results of statistical analysis are very much, determined by the variables that are chosen and decisions, key decisions that are made in terms of how the analysis is conducted. So, for example, Harvard included what they called ALDCs, and these are their athletes, legacies, children of faculty members, and what they call dean's list. So these are students who got special attention from the dean, and this is 30% of Harvard's admitted class. SFFA's expert omitted 30%. All of these students in its statistical analysis. Another key difference between these two statistical analyses is that the Harvard expert analyzed each year of data separately to mirror the admission of students each year. SFFA's expert instead clumped all of the years together and did an analysis that way. So Dr. Card looked at each year separately, and because he thought that would best kind of portray the admissions process, because students are competing against each other on a year-to-year basis, not all 6 years of students together competing against each other. So that was one major difference between the analyses. Another was variables that were included in, or information that was included in the statistical analyses. There's been a lot of discussion about the personal rating, which is a subjective score that included personal essays and teacher recommendations and so forth, which is very hard to quantify in a statistical analysis. SFFA's expert included the score, but also included the intended concentration, parental occupation, and the results of an alumni interview. SFFA's expert decided to exclude those variables. The trial took place over almost 2 weeks. There was a tremendous amount of information that was shared during the course of the litigation. 480 admissions files, data from approximately 150,000 student applicants. And the court found no evidence of racial discrimination. The only evidence put forward by SFFA in support of its claim for discrimination was its statistical analysis, which is ironic because civil rights lawyers use statistical analysis all the time to try to show some sort of race effect, and it's been very difficult for civil rights lawyers like myself to bring these kinds of cases without other evidence of racial discrimination. And yet here we have a situation where there was evidence that the primary evidence that was relied upon was statistical analysis, the statistical analysis without some corroborating evidence of discrimination. And then I wanted to show this picture of some of our clients at the Supreme Court on the day of the argument. It was really it was a day of contrast, because when we were inside the courtroom and it was a marathon argument, there were questions raised by some justices like Justice Thomas and Justice Alito, really questioning, what are the educational benefits of diversity? What is diversity? What does it mean? Does race even have any meaning? And then, in stark contrast, you had all of these students outside of the courthouse, students from all backgrounds, students and alumni of all racial backgrounds from different universities, different colleges, different parts of the country, really rallying in support of affirmative action and kind of speaking their voice about how important it was to have diversity in their educational experience. So that was a wonderful sight to see, and it's a shame that the justices themselves weren't able to see that themselves, because it was a real contrast between what was said in the courtroom and outside the courtroom. So a question that many people have is how will the Supreme Court rule? And as I said, it's very unclear. I don't want to predetermine, and I don't think people should predetermine that we know what the Supreme Court is going to rule, because there are a lot of different possibilities. The one result that we often read about in media and people opine about is the possibility of the Supreme Court outright, banning affirmative action, which is certainly possible because we have a different Supreme Court today than we did when the Fisher decisions were decided. I do want to emphasize that would be a tremendous sea change in the law. This is something that would be quite dramatic and really destabilizing, both for the court's jurisprudence as well as emissions policies all across the country. But that is one possibility. The other possibility is that the Supreme Court can say that the affirmative action programs at both Harvard and University of North Carolina are perfectly legal under existing Supreme Court law. And that is what the trial courts and the First Circuit Court of Appeals have all decided, relying on binding precedent and the law that's been in existence for almost 5 decades, that these affirmative action programs are perfectly legal. And then there's something in between, and there's a lot of possibility in that in between space. The Supreme Court could reaffirm the law and saying that the law remains the same, but perhaps there's something about these affirmative action programs that don't comply with what the law is right now. There could be a sense that the lower courts did not look at the facts correctly, and the Supreme Court could remand the cases back to the trial courts. The Supreme Court could make a distinction between private universities and public universities. So there's really a wide array of different possibilities, and I want to dispel the notion that the only result would be the first, that the Supreme Court is going to ban affirmative action, which is what we read about a lot. Now, again, I don't want to be naive and say that it's not possible, but I don't want to presume that it's the only possibility. And in fact, there's a wide array of possibilities. We have 9 justices who all have differing opinions, express different opinions during the oral argument. So that is the end of my presentation. I really look forward to the questions that you all have, and I really want to thank you for this opportunity to share some of the information that I had about the two cases.
Let's try this now. Hi, my name is Willard Stanback. I'm an alum of the Institute. I'm class of 85, a year behind Patrick. After leaving MIT, I went to grad school. I also went to law school. So on a personal note, Jen, I'd like to thank the Legal Defense Fund for everything it does, but also personally thank it because I was one of the recipients of one of your scholarship programs. So, and I want to put a little bit of a plug in that the Legal Defense Fund still is looking for people to provide donations with respect to not just this particular matter, but with all the matters that you're addressing on a day-to-day basis. I'm going to just jump right in with some questions. They're not going to be in any particular order, but as a lawyer, I had a question with respect to, you talked about the intentional discrimination. So I was wondering if you can tell us a little bit more about that, because I'm interested in understanding what the case is and what the courts were looking at in terms of intentionality. What were the factors that they were trying to look at to decide whether or not Harvard was intentional in their discrimination?
Yeah, it's interesting because the legal arguments that SFFA made evolved over the course of the case. So in the beginning, the SFFA had made this argument based on a case called Arlington Heights. And this is a situation where if you have a facially race-neutral law or policy, how do you, was there an intention to discriminate, even though it's, facially race-neutral? And the Supreme Court in this case, Arlington Heights, said that you look at different kind of circumstances. So you can look at statistics, and you can look at comments that were made around the time. You can look at the history of the policy. You can look at whether or not there's something unusual about the development of the policy. There's just a lot of different factors. It's non-exhaustive. And so they kind of relied on that kind of analysis to begin with. Really relying heavily on the statistical analysis, as I mentioned before. Then sometime during the course of the litigation, they switched gears and said that because this was an affirmative action policy, that it was really the burden of Harvard to disprove discrimination. That if SFFA showed some sort of discrepancy in the statistical analysis, unless Harvard showed that there was explainable, then or justified in any way, then there must have been some discrimination, which is really unusual and kind of flipping the burden of proof, like who needs to prove discrimination. And I have to say, again, as a civil rights lawyer, it's incredibly difficult to prove intentional discrimination. And there's many circumstances, because I also do, for example, policing litigation, and there's many circumstances where we bring statistical analyses about discrimination by law enforcement officers, but there's always some sort of like explanation for that disparity. And there's always, you have to look at every single variable. You have to control for so many different variables, and that is not the case in this instance. But the other thing that I think is really important is that there's been a lot of emphasis on whether or not there was discrimination against Asian Americans, and I think anyone would want to take those allegations very seriously, and I don't want to say that there is no discrimination or no bias at all against Asian Americans. But what I think is really important is, and what's often overlooked, is that there's also discrimination, and this has been well documented, that there's a lot of discrimination against Black students and Latinx students and Native students as well. So to say that this was a unique problem for Asian Americans and that they're uniquely disadvantaged from affirmative action is really not the way the world operates.
Okay, thank you for that. somewhat tangential to that. I want to make sure that I understand and the attendees understand when you're talking about 100 factors, right? And the courts and this litigation is just focused on one. Is there a discussion about the weighting of the factors in terms of race versus the other 99, or how that aspect of having so many factors, how does that play into the case one way or the other?
That was part of the analysis that Dr. Card made on behalf of on behalf of Harvard. He weighed the different factors that was considered in the admissions process, and found that race was actually not as significant as, say, for example, intended concentration, or some of these other factors that had a much more effect on the chances of someone being admitted to Harvard, as opposed to not being admitted. But I think one of the things, this is just a really good example of how statistical analysis can really just differ based on, the way that the analyses are conducted, because even though SFFA found that Asian Americans were less likely to be admitted, Dr. Card found that actually when you broke down Asian Americans, Asian Americans from California were more likely to be admitted than white students to Harvard. And Asian American women had a higher chance or more likely a slight, not too significant, not statistically significant, but had a higher likelihood of getting admitted. So it just really shows how you can parse the numbers in different ways to get different results.
Okay, I'm going to switch gears on you a little bit. There's a question from the attendees, one of them about Justice Brown Jackson and her recusal, and how that may have some type of a impact on the decision that she's going to be not involved with.
So it actually is not going to have, you think about Justice Jackson, because she is not at play in the Harvard case, assuming that she would be the deciding vote, you would think that there would be equal 4-4 one side, 4 side for the other. And if that's the case, then the lower court's decision stands. So you need a majority to overturn the lower court's decision. If there was, say it was 5-3, for example, 5-3 to overturn the lower court's decision. In that instance, it wouldn't have made a difference if Justice Jackson was on the court or not, because it would be 5-4, versus 4-4.
Okay. So at the beginning of this, you talked about how this is really a education case, but I have a question, and I'm assuming others may also, in terms of whether or not there's a possibility that others now, based on other cases that are pending, or others in the future, may use this as a platform and a springboard to try to go after other types of affirmative action programs.
Yeah, that's something that has come up a lot, especially in the business community, and concerns about, for example, DEI trainings and and initiatives and affirmative action programs in the workplace. And one thing is to be very clear that the law that developed around affirmative action in higher education is very, very specific. And so that law in Title VI is very different from the law governing workplaces like Title VII. So it is very different. The other thing is that there's no situation in the workplace where there's race is explicitly considered as one of many, many, many factors. And so, but there's certain, and so, when we talk about affirmative action, we're talking about a very, very specific program. But I think what this highlights, people's concerns highlight the fact that there's a general attack on issues of racial equity across the board. And that is certainly true, because you see that in this kind of rhetoric against critical race theory. You see that in the K through 12 context. You see that in these challenges to DEI programs. And so, for us at the Legal Defense Fund, we just think that it's especially important in this kind of context to be unequivocal in support of, racial equity, because there is just so many attacks. If you give an inch, you're going to give a mile. And it's really important in terms of educational, not just educational equity, but employment equity, equity in housing and so forth, to make sure that is always on the agenda, that that's very clear that there's an imperative and urgency to ensuring racial equity. The other thing that I think is really important in all of this is just the underlying stereotypes that pervade a lot of these challenges to affirmative action, which is also replicated in other areas as well. Because there's a stereotype, the fact that there's this case that was brought against Asian Americans, there's a stereotype that, Asian Americans do better in school or better in education. And to some extent that there must be some implication that they're smarter. And that's a really dangerous stereotype to have, because that also implies that other people may not be smarter. And this is all, kind of racialized stereotypes. And I would just say, just even for myself as an Asian American who didn't do very well on my standardized test scores, these stereotypes are many times not true. And so it's something that we have to be very careful about.
Okay. That kind of dovetails into a question from one of the attendees about affirmative action and efforts to actually strengthen it and keep it alive. So I don't know if you have any thoughts on things that maybe your organization is doing or someone else that are, as opposed to just doing, responding in litigations, are there other efforts to actually promote affirmative action?
Yeah, one thing that I think is just really important is to find out what the Supreme Court rules, because that'll determine what is possible legally under the current Supreme Court. But I think that's absolutely right. No one in many ways, that first case, the Bakke decision that kind of set the parameters for affirmative action, was considered a loss by civil rights groups, because it really constrained what colleges and universities were able to do in terms of advancing racial equity in higher education. And so certainly, affirmative action is not the end all be all, and not considered to be the answer to all the problems within the educational system. We need to look at our K through 12 system. We also need to look at the admissions process. For example, advantages that students have with AP classes, with calculus, with these certain very, very competitive extracurricular activities and so forth. Even test scores are very much determined by resources, and oftentimes not an indicator of ability or merit. And so these are all things that should be, I think, re-examined by colleges and universities, but looking at their admissions process, especially once the Supreme Court has issued its opinion, so we know what the parameters are.
Right. I'm going to paraphrase a question that came in from the audience, and it's about statistical data regarding graduates. So I'm wondering, and this may get to the meat of this question, as part of these cases, have they actually looked at the graduation rates of the people who came in who, based on the analysis, without affirmative action would not have been at the school? Or was there any discussion about that in terms of cases?
Well, I don't think that there was any discussion about the trying to, in some ways, it's really hard to determine who exactly would have been admitted, or, down to that granular level. But we, in our amicus brief, did submit some evidence of studies showing that, Black graduates of law schools and universities were just as successful as students of other races. So kind of refuting this notion that somehow, they were any less qualified, less able to kind of compete in the workforce afterwards. But I don't know of any studies that looked at individual, like specific graduates and following them and determining, what their, what their kind of career trajectory was.
Well, let's go to the front side then. You talked about the change in the number of admitted students if we don't have affirmative action. Can you give a little bit more information of that analysis in terms of what were the factors that were used to try to figure out what that difference would be between the number of students coming in with affirmative action versus without?
Well, I think that, this is all probably beyond my expertise as to the specifics, the specific analysis, and I certainly don't want to pretend to know something I don't in this audience. I will say that I think that there was some controlling of factors to determine whether or not race would, like the influence of race in determining, in making the determination as to whether you'd be admitted or not admitted. It's obviously an incomplete analysis because, as I said, there's a lot of qualitative information that is hard to quantify. Like you can just obviously be the essay and how that might influence a particular decision. But I think that what I can say is that there was an agreement between both experts that if Harvard does not consider race, that there would be a tremendous decrease in the number of Black and Latinx students. So even though I'm sorry not to be able to go into the details of this, exactly how the analysis was conducted, but that was really not in dispute as to the number of the fact that there would be such a tremendous decrease. What I think was in dispute is whether or not there were some, what was called race neutral alternatives that could counterbalance that effect.
Mm-hmm.
And but what was really interesting, because for example, SFFA argued that Harvard could, just not rely on standardized tests, or they could, do a lot of these other things. But what was really striking is that even SFFA acknowledged that in their best case scenario, the number of Black students would be decreased by 1/3, regardless of any kind of other measures that were taken. So it's going to have a tremendous impact on students, no matter what.
So do you think that, I'm thinking about our school, the Institute, and we have race-based, let's call it, organizations and programs that have some racial aspects to it, like summer programs and other things. Do you think that a decision on admissions could possibly be used or be the catalyst for people to go after other programs that higher education institutes may have?
Well, I don't think we need the Supreme Court decisions for people to go after those programs, because some of these conservative organizations are already going after these programs. And we actually we took a look at some of the lawsuits that were filed against DEI programs and things like that, or race-based programs, and haven't really found any that have been successful. But again, I think there's a tremendous difference between programs that are trying to increase recruitment or increase opportunity, and a program like affirmative action in admissions, where where it's explicit, where we're talking about an actual admissions decision, because there's just two different areas of law. But again, you're absolutely right that there's probably that there are already challenges, so there will undoubtedly be challenges regardless of what the Supreme Court decides, because all of these kinds of programs have been attacked by a lot of these conservative groups.
Okay. Another question from the attendees. They want to know from you, or your perspective of how the definition or the consideration of affirmative action has changed since it's been established. So you kind of talked about the parameters of what it is and what it's not. And I know we talked about how it's been attacked in certain cases. Has there been a narrowing? Has there been a broadening? Or what has been your experience in terms of looking at these, how affirmative action has been defined over time?
Mm-hmm. Well, before the Bakke decision, that was the very first decision that the Supreme Court issued in 1978. there was a lot more flexibility as to how to use affirmative action. And that decision really went through different possible justifications for having affirmative action, like, for example, remedying societal discrimination, or the importance of having more Black doctors in the medical field, and so forth. The Supreme Court went through all those justifications and said they weren't enough, that the two justifications for having an explicit consideration of race would be remedying a specific act of discrimination. So that's always going to be the case, is that if there's a specific act of discrimination, you can use race to kind of remedy that, or the educational benefits of diversity. So that's why since 1978 to the present, when we talk about affirmative action, we talk about the educational benefits of diversity. We're not talking about, remedying societal discrimination or the importance of having more Black doctors or more Black professors or more Black mathematicians and so forth. And that's been very constraining. I think a lot of people have criticized that, because that doesn't really, for some people, affirmative action is about remedying societal discrimination. And so, having to couch the terms of affirmative action for in terms of the benefits of diversity, changes the conversation as opposed to remedying discrimination. The other, I think, kind of changes that have happened is, for a while, affirmative action was, considered a bad word, like there was a negative connotation associated with it. I think many in the civil rights community are trying to push back against that, because that's really having the other side dictate the narrative and dictate our use of language. And we see that now with, the way they've mischaracterized critical race theory. So there has been a lot of changes over the years, and there may be changes after the Supreme Court decision. I mean, we have to wait and see.
Okay. Another question from the attendees is about the SFFA support from the API community. Can you speak to that?
Yeah, I mean, it's certainly true that there's a kind of a very vocal group of members of Asian American Pacific Islanders who are very much in support of SFFA and are very much opposed to affirmative action. It's a divided issue within the Asian American community, but it's not the majority. It's actually the minority that is opposed to affirmative action. The majority are very much in favor. And I think the fact that, the Harvard Asian American Alumni Association, as well as all the major student organizations, the Asian American, the Pan Asian, Asian American Association, the Chinese Association, the Korean, Japanese, all of the major, Vietnamese, all of the major associations came out in support of affirmative action, really shows that there's actually a tremendous amount of support of affirmative action within the Asian American community. But there's certainly, I don't want to deny the fact that there are many who are opposed, but they're not the majority. And sometimes I think people misunderstand that because they are so vocal. They think that that's reflective of the entire Asian American community or the majority of them, and that is not the case.
Okay. So I know we're waiting for the ruling from the court. Is there anything that like the MIT, the Institute, or our alums should be doing, and aside from, attending seminars like this so we can get educated on the subject, is there anything else that people who sit in our kinds of positions should be doing with respect to this case and what may be happening when the ruling comes about?
Well, I think there's been a concern right now of colleges and universities, and I don't know about the Institute, but colleges and universities predicting that affirmative action is going to be banned and taking some steps backwards in terms of trying to foster diversity and having, racial equity is have a commitment to racial equity in their school. And I think it's important for alumni like you, who especially to have influence over the administration to ensure that they maintain their commitment to both diversity and racial equity, regardless of what the decision, ultimately is. Like I said, when the Bakke decision came down in 1978, many people considered that to be somewhat of a loss, but
Mhm.
people adapted. They were able to still, use the law or take the law as it was and try to still ensure that there's a diverse student body. That's the same that's going to happen regardless of what the Supreme Court decides. Whatever the decision is, like, we should try to find a way to work within the law to foster diversity, but also racial equity.
Okay. Can you tell us a little bit more about the amicus speaks from the corporations? Because I'm curious as to, it's one thing to say, yeah, we agree on diversity, but I'm wondering if they spoke to if something were to be different with respect to the law, if they would step up and do something different themselves, or if they just kind of stopped short and said, we just think the law should stay the way it is right now.
Well, I think the brief was to support the law as it is right now, and to make sure, that because that's what's before the court, and to explain to the court how important it is to maintain affirmative action, both in terms of the pipeline of employees that would be going into the workforce, and why diversity is important in the workforce, and how specifically it's very much related to productivity and commercial success to have diversity within the workforce in all kinds of industries. So I think that was kind of the and explaining in detail like how that operates within the workplace. I think though we've been having continuing conversations with the business community about, just as I kind of said, was talking to all of you about alumni putting pressure on universities to, maintain their commitment to diversity and equity. We've been having the same conversations with the business community that, just find, they've kind of shown their commitment, that they had an important voice in this battle, and then they should continue to exercise that voice. Regardless of what the opinion is, that that colleges and universities need to continue their commitment to diversity and equity.
Okay. There's a question from the attendees about non-US immigrants, the citizens and the dreamers, and how this may play into their situation.
Well, interestingly, the statistical analysis that was conducted in the Harvard cases excluded non-US citizens. So that wasn't a part of the analysis. I think international students are very different in terms of how they were being treated by the parties in the cases. For undocumented students, it's really unclear. I think that the whole issue of immigration status is kind of, again, a completely different body of law, which is very different from the notion of whether or not you can consider race, among many factors. Now, certainly to the extent that undocumented students are more likely to be of a particular race, then they may be impacted just like students of the same race. So, Black and Latinx students, Native students, those are the ones, and many Asian American students too, because Asian American students benefit from affirmative action as well.
So I want to go back to the factors. There are other factors I would imagine, and you can tell me if I'm not thinking about this the right way, that kind of are around or approximate to the factor of race, be it where you live, what your family is like, whether or not you're a first-time college student. Was there any discussion about what I'll call the surrounding factors that may have some type of relationship with race, or how do those factors that are closer to that element, that characteristic, how do they kind of play into this?
Well, I think that's a really interesting question, and that came up in the oral argument actually, because Justice Ketanji Brown Jackson made the comparison of, and this is for the University of North Carolina case, of a situation where a white student applicant would write in his or her essay about having generations of ancestors who went to UNC, and this could very well have been a family that lived in North Carolina for a very long time, had been plantation, had been and slave owners, and and you know, and then you compare that to potentially a Black student who is a descendant of slaves, and when the question was raised, would that student be able to talk about how that, you know, his or her family was denied admission to the University of North Carolina for so long, and would be the first generation to be to be attending UNC, and what it would mean to the family. But would that student be able to even share that information because of the close association between race and being descendants of slaves? And so I think that really goes to show how complicated this issue is, because what SFFA has said in its litigation is that they don't want colleges and universities to know the race of any student applicant. And just thinking about how that would operate, like how to operationalize that in practical terms, like how can you, like, does that mean redacting people's last names, for example, or first names? Does that mean redacting, imagine like artists, a dance performer not being able to submit a video of a dance performance, or someone not being able to talk about the church that they are really active in terms of their community service because it identifies the racial or ethnic background.
Right.
So it's much more complicated, obviously, just as you pointed out, to just say, not consider race when there's so much about race that might inform a person's personal experiences.
And I would imagine for many of us, it's not even put out an address.
Right. And then
Applications.
absolutely at the school that you attended. I mean, there's just so many different, different ways of determining, whether what a person's race or ethnicity is.
Right. A question from the attendees about the Yale case. Are there any unique aspects of that we should be thinking about?
Well, what was really interesting about the Yale case, and again, this is an argument. It was a claim of discrimination against Asian American students. And in the Yale case, they actually distinguished Asian American students. I forgot the language they used. I think it was, what was they called, like preferred and non-preferred Asian American students. But essentially, they disaggregated the race of Asian American to East Asians and Southeast Asians, and saying that affirmative action discriminated against East Asians. So it's kind of so in that case, they're kind of even redefining the race category of Asian American, which is obviously intentional because it helped prove their claims more than and I think this is in direct response to evidence that came out in the Harvard case that there's many Asian Americans that benefit from affirmative action. There's a rich diversity of, Asian Americans within the larger kind of racial category of Asian Americans, which is true for other races as well. I mean, that's the other thing that I think was important in coming out in the litigation, is that you can't, you shouldn't stereotype and assume that all people within a particular racial category are the same.
So another question, I'm trying to figure out how to phrase this in a way that makes some sense to me, is asking about, the statistics that were provided and how embedded in there is there maybe an impact with respect to gender. So if you look at the races and then you look at Black women versus white women versus Asian women, is there a disproportionate type of change with respect to that when you look at those drops?
Well, I mean, that's what Dr. Carr did, is he did look at gender and determined that Asian American women were more likely to get admitted to Harvard as opposed to white women. I mean, it was only for certain years, I think, and it was a very small likelihood. But I don't know of any other kind of breakdowns when it came to gender. Based on other races. What was interesting about the intentional discrimination claim is that the SFFA compared Asian American applicants to white applicants. So they were discriminated against white applicants. Although what was implied is that they were being discriminated, that Black and Latinx students were getting some sort of advantage, but they didn't make that claim explicitly because they kept comparing them to white applicants. So that kind of made the analysis somewhat complicated, because what you know, in kind of conducting its statistical analysis, then they would sometimes compare Asian Americans to Black students and to Latinx students and so forth. But I'm not sure about any kind of breakdown by gender.
Right, I understand. The guy who's the founder of SFFA, can you speak to, because I think I read somewhere about some of the people who are backing him and the amount of money that's coming into his organization. Can you speak a little bit to that?
Well, I only know, what's been reported in the media, and I'd sent around an article that that had been circulated about that very issue. It's certainly true that he has a tremendous amount of financial resources because they have been, litigating all across the country. And I also think, you take a step back and think about all the financial resources that have been going into this litigation to end affirmative action. And if all of those resources could have been used to actually fix our educational system, because there's so many problems within both our K through 12 and higher educational system, it really is a waste of resources, because you think about all of the money that's been put into litigation just around the issue of whether affirmative action should exist or not. And we're talking from both sides, both the university as well as the people that have been backing them. It's, to me, it's a tremendous loss, because that's resources that could be better spent.
Yeah, that goes a little bit back to that question I was asking about the corporations. I know at BAMIT, when I was involved more than now, we were looking into doing things in the high school level and even younger than that. And we were looking for corporations to come and help us with those type of initiatives. So I was wondering if some of these corporations who are looking at this now and seeing that, there's a battle at the college level, are thinking, well, maybe whatever happens here, I know I need to start working before college to try to even up that playing field that you were talking about at the very beginning of your presentation.
Yeah, that's certainly true. Because we're not going to fix the system just by looking at admissions to higher education. The K through 12 system itself needs a lot of reform. And we've always, that's a big part of the work that we do at LDF too, is our K through 12 work. We still have many school desegregation cases as a legacy of, the Brown litigation.
Okay. So I'm looking through the questions to see if, oh, something just popped in. Please. Oh, okay. So there's a question about, we're talking about these two Supreme Court cases. Can you give us any enlightenment on what's going on with your efforts on state levels?
Yeah, what's really hard is that if the Supreme Court, whatever the Supreme Court rules, if it's based on the US Constitution or Title VI, that will probably trump whatever affirmative action, litigation could happen at the state level.
Mm-hmm.
And especially because so many state colleges, universities receive federal funding. So they would be subject to Title VI, even if they were a private university. So, again, it really depends on what the Supreme Court rules, what the Supreme Court, the US Constitution is kind of considered the floor, and everything needs to comply with the US Constitution.
Right.
Greater protections under the state constitution, but certainly not less.
So, and you said this, I just want to make sure everybody's clear on it. So right now, it's been oral argument with the Supreme Court, and then we have to wait for whatever the decision is going to be. And then based on that, we'll have to see what, if anything, that we need to do differently. Do you have a sense that the parties who have brought this case, even if the case is ruled against them, that they're not going to come back in some other form to try to do something else? Or what's your thought on that?
There is there are a few things that I am certain about in the world, and I am 100% certain that they will continue their litigation if this case continues. Like they have, as I said, they filed a lawsuit against Yale. They have a lawsuit against the University of Texas. There's certainly other law schools that are potentially a target for litigation. So it would not surprise me at all if they continued filing lawsuits, regardless of what the Supreme Court rules.
Okay, there's a specific question with respect to BAMIT, to the extent kind of already who we are and what we do. And that question is, what do you recommend that our BAMIT community do at whatever level, be it local or national, in connection with this subject?
Yeah. Well, I mean, obviously you're a tremendous and important influential voice in the Institute community. And so I would say just continuing that influence to ensure that they remain committed to fostering diversity, especially for Black students, regardless of what the Supreme Court rules. I think that's probably one of the most important things, is just to maintain pressure that colleges and universities, that administrators know that there's a lot of different considerations that I know that they must have in terms of potential lawsuits or different constituencies and different interests. But I think making sure that this interest is high on their list is important, and to keep that pressure on.
Okay. Well, we as a community consider ourselves to be problem solvers. So I think that you'll find out that after this, and when we have some more discussions with the representatives of the Institute, we'll probably come up with some ideas of what we think the school should be doing in this regard. A more specific question, someone asked, what should we be doing to help your organization with respect to this?
Well, I would love to continue the conversation, especially if you're a group of problem solvers. I'd love to continue the relationship, because we always need problem solvers to help us too. I don't want to profess knowing all the answers. And so, after this decision comes down, I would love to, just continue this relationship and this conversation. I think, MIT is an important educational institution, an important voice, and all involvement with like amicus briefs, for example. We represent students and in the Yale case, actually, a diverse group of student groups. And so there may be opportunities for alumni groups like yours and from other universities to weigh in, at different times. And that's a possibility, just like, what had happened in the Supreme Court. And then, obviously, we welcome financial support for LDF. We're a nonprofit organization. We try very hard to do the best we can with the resources that we have. There's, it's always the case. I've been at LDF for 15 years now, and we've grown tremendously and over the past few years, but it's just the more we grow, the more work there is to do. And there's always more work than we can do. So,
well, I'll pat myself on the back a little bit. I did try to give enough donation to cover the scholarship that I received.
Oh, so. That's very fun. Yeah, and we also have that scholarship. We have scholarship programs, and we have a new scholarship program called the Marshall Motley Scholarship, which is funding law students specifically to they have to commit to doing civil rights work in the South.
Oh, wow.
Yeah, and it's a full ride, so we pay for all of their expenses, all of their tuition. In exchange, they commit to doing civil rights work in the South after they graduate. So we're very excited about that.
All right. Well, I have another question from the attendees, which I'm going to read because I'm not sure what you may or may not be able to do with that. But based upon the analysis conducted through these cases and the 100 factors you mentioned, can you speak to what percentage of the admissions is based on academic performance and what is due to other factors like personal data?
I don't know of any data that kind of like that goes down to percentages, like what kind of percentage the impact is. And I don't want to say that, academic data isn't influential. I mean, it certainly is. And in fact, I think, Harvard is not one of the institutions that is disavowing the SAT. I mean, they continue to want to rely on the SAT for its admissions program, so yeah, so I don't know of any kind of part of the analysis that broke it down into percentages like that.
Okay. Let's see, I'm trying to see if there's any other questions that I have missed here. And I'm speaking indirectly to my handlers to make sure that they send me any other thing that they may have in the queue. So let me ask this, Jen, is this kind of 24/7 for you in terms of these cases, or are you working on cases that are outside of this space, or what's going on in your world with the LDF?
Yeah, so my title is Director of Strategic Initiatives and a new department at LDF. It was just created last September called the Strategic Initiatives Department. And it was created to house 4 initiatives that kind of lends itself to more integrated advocacy. So integrated advocacy meaning litigation, policy, communications, organizing, and research kind of working together. So affirmative action is a part of what we call our pro-truth initiative. And that also includes just this attack on K-12 education, critical race theory, and those kinds of things. I also am in heading within the strategic initiatives department, what's called our Justice and Public Safety Project, and that deals with racial bias in law enforcement. We also have a Prepared to Vote voting rights defender program, which deals with election protection and year-long civic engagement in the political process in the Black community. And then we're launching a housing redressing housing segregation program.
Okay.
So this takes up a lot of my time, and it's an important issue, but it is one of many things that we have going on just within the Strategic Initiatives Department. That's just my department, and not even including everything that we're doing at LDF.
Wow. All right. Well, thank you for all of that.
Well, thank you. But I have to say, I feel very lucky, and I've been at LDF for 15 years for a reason, because I feel very lucky to be able to do something that that I not only feel passionate about, but just working with just wonderful colleagues and clients.
Okay. So one question that came in from the attendees was to ask you what questions you have of us.
Oh my goodness. Well, I guess one question I have is, do you feel, as I've talked to a lot of people about this, I think a lot of people feel, and I understand why, somewhat pessimistic about the future because of the court, and because of the way the court has ruled in previous decisions, in recent decisions, and what might happen after it decides these affirmative action cases. And I guess what is it that we at LDF can do, or the civil rights community can do, to kind of dispel that pessimism, and to have, for people to feel hopeful, and to be able to feel like we actually can make progress regardless of what happens, regardless of all, even if there is a setback.
Unfortunately, I'm the only person that can speak for the audience right now. What I will tell you is that I'm going to try to channel some of the people that are probably attending. Even though there may be the notion of some pessimism, many of us have gone through a whole lot of hurdles and obstacles to get to where we are. And we amongst ourselves, I believe, discussed that it's always going to be a battle.
Yeah.
So that it's pessimistic in that we still have to do the battle, but it's realistic in terms of we know we have to do the battle. So I'm hoping I'm not mischaracterizing what we as a group may be thinking or doing with respect to how we view this particular issue and similar issues and how they impact the community.
That was a wonderful answer.
So Patrick's going to say that I was all wrong, but that's okay.
Not a chance, not a chance. I think you very thoughtful and spot on. You know, I think these sorts of activities where you really help dissect the nature of the battle are very helpful. In fact, a friend of mine reminded me today that we actually did some work, BAMIT and the LDF, about 20 years ago. Similar kind of scenarios, similar kinds of engagement and collaboration. So there is already a history here, and I want to make sure that we continue to work together, to collaborate, to find ways to increase awareness and understanding throughout the community, to understand where there may be opportunities for the different communities to collaborate and work together to plan for and adjust and change strategies, develop strategies, and so forth. So I just want to take a moment to just say thank you. I mean, this was really a great topic, great discussion, very enlightening. I know I learned a good bit just listening to all that you shared, as well as some of the reading that you shared in advance. I do want to encourage the audience, those who are here. First, thank you all for dialing in, connecting in, and listening. Thank you for the good questions, but I also want to challenge you. You know, there are opportunities through BAMIT as well as through other organizations. Please, please, please continue to bring your energy, your intellect, your passion, your fight, your willingness to help us to make sure we are looking at this every which way and all the angles and upside down and so forth, so that we find the better solutions, the best approaches to neutralize these very powerful sources of funding that are masquerading as, you know, just a one individual shop who's just trying to fight the good fight, when in reality it's a very well orchestrated battle against affirmative action, against equity, against racial justice and social justice. We've got to make sure that we're continually shining the light and demonstrating where's the truth there. So I really appreciate the work that you're doing through the social truth and justice actions and work that you're doing with LDF, Jin. And I just need to say thank you again, and thank you to Moana, the entire Alumni Association, for their support and for all of the effort. This has been tremendous. And one of the things we hope to do as well is, but maybe by the time that the ruling comes out, see if we can bring you back and see if we can have the MIT leadership participate, and maybe we can have a working session and talk through their thinking about what the ruling means for MIT, and ways, again, that the community can work together with them to avoid taking a step back, if you will, going 20, 30, 40, 50 years backwards as a result of if the ruling goes a certain direction. So I hope we can do that in the future when the ruling comes out.
I mean, I would love that. And I also just want to thank you for inviting me to speak to all of you. And you know, it was invigorating, very challenging. The questions were not easy, but I think that says something about your membership and the institute and its graduates. But I would love to continue the relationship, and it's good to hear. I mean, I wasn't aware of the collaboration 20. I would love to hear more about that, but certainly would love to have collaborations in the future.
Great, fantastic. So thank you. Again, thank you. A special thank you to Willard, who represented BAMIT well, as always, stepping in and being our host, working and talking through these really important questions and so forth. Always good to see you. And I just want to wish everyone a very special evening and special week. Thank you for continuing to do the good work that you all are doing. And I hope you will be inspired by this webinar and the other activities that BAMIT is putting on, and that you'll get more and more engaged, right? Participate in and support one or more activities, If you haven't joined BAMIT or rejoined, and make sure your membership is current. We're posting here the code. You can either use the QR code or go to the bamit.org/membership page, renew your membership, and then engage. Pick a topic, add your voice, help us to have the kind of impact that we know we can have, and also the reminder, with the kinds of blessings that we have had and received through our lives comes the added responsibility of doing more and doing for others, right? Each of us lifting others up, making sure that the door stays open and gets even wider open for others. Support a BAMIT committee, right? There are things like our Outreach and Engagement Committee, the K through 12 STEM Committee, and many others. And donate and help BAMIT. We're going to be doing some fundraising in the coming months. Please, please, please support the fundraising as well. We've got great programming committee, and we have some advocacy efforts like this one as well. Get a classmate or friend to get involved with you, and just participate in the various activities. With that, I just want to say thank you and have a great evening.
Thanks for joining us. And for more information on how to connect with the MIT Alumni Association, please visit our website.